Good morning, guys. This is Riya Shetty from Jitendra Chauhan College of Law, and today I'm going to be talking about the recent case of contempt, that is the Yatin Narendra Bhai Oza contempt proceedings, which took place in the year 2020. This is the most recent case which took place. So I'll be telling you all about that. Just give me a minute. Yeah, so Advocate Shri Yatin Narendra Bhai Oza, who was the president of the Gujarat High Court Advocates Association, who later went on to being designated as a senior advocate of the Gujarat High Court Bar Council, called upon a live press conference during the course of which he leveled certain filthy and contemptuous allegations of corruption and malpractice against the registry of the High Court on frivolous grounds and unverified facts. Via his remarks, he went on to question the very credibility of the Gujarat High Court administration, labeling it as a gambling den that very selectively catered to the needs of only litigants with money and power. Having noted that despite the apology granted to Advocate Yatin Oza in 2016 by the Apex Court for a similar act of contempt, nothing much had changed, and the two-bed bench of Justice Ms. Sonia Gokani and Justice N.V. Ajarya, having found the statement representations made by the contemner in a public domain to be an act which lowered the authority of the High Court, registered a suo motu criminal contempt notice against the respondent under Article 215 of the Constitution, read with Article 15 of the Contempt of Court Act 1971, and issued the same to the respondent under Section 17 of the Act, along with the order and the entire material on record. Further, the contemner had been restrained from making any scandalous remarks or holding official meetings and passing resolutions or circulating any material or communicating on record. On the 10th of June, the full court of the Gujarat High Court unanimously resolved to have proceedings in relation to the withdrawal of the conferment of title which had been given to him initiated. Meanwhile, on the 11th of June 2020, a leave petition had been filed before the Supreme Court by Advocate Yatin Oza, challenging the 9th June order that he had eventually ended up withdrawing. The contempt proceedings initiated against him ended up with a collective decision of the full court on the 18th of July review and recall Advocate Yatin Oza's senior designation, which was granted to him, which went on to be challenged by the contemner as being violative of Article 14, 10, 1G, and 21 of the Constitution of India. In this ongoing case, in order to be able to draw a conclusion as to whether the contemner had accepted or his apology should be accepted or rejected, it was the element of bona fide apology which needed to be taken into consideration. Okay. So, in order to be able to understand what exactly amounts to a bona fide apology and whether the apology of Yatin Narendra Oza should be accepted or rejected, there were certain issues which were brought up as to whether the act of contempt was a repeated performance, was the act of contempt made at the first veiled opportunity, was the apology really genuine, and was it in a real sense an unqualified apology that was filled with remorse. After Advocate Yatin Oza's senior designation had been withdrawn, he had moved to the Supreme Court, during the course of which he expressed that the apology which was made by him was very wrong, and he asked the court to drop the proceedings against him. However, the Gujarat High Court had completely rejected his apology, stating that the apology was nothing more than a paper apology. Taking this into account, his apology had been rejected, and the bench of the Supreme Court was of the opinion that it would be incorrect to pronounce the contemner guilty of contempt, as there were several factors which still required to be assessed in order to draw a conclusion over the matter. The Supreme Court further suggested that the matter should be heard by an appeal against the decision of the High Court, thereby permitting its counsel to provide a copy of the same against the High Court to the other parties until September 29. In the original criminal contempt case of Yatin Oza, Section 12 of the Contempt of Court Act, stating that a contemner that provides an unqualified apology to the satisfaction of the court will be discharged of his punishment. Yatin Narendra Bhai Oza had his apology had been rejected time and again, and he had termed the Gujarat High Court Bar Association registry as a gambling den, which was wrong in every aspect. So, in this sense, in order to be able to judge whether his apology, which was now being made before the court, was an unqualified apology, whether it should even be counted as one, was something which needed to be thought to a great extent. So, having considered all this in the ongoing case in the Supreme Court, it would be too early, in my personal opinion, to draw conclusion over the matter. But there have been two recent cases of Justice C.S. Kannan and Prashant Bhushan. On one side, where Advocate Prashant Bhushan was let to go away by just pronouncing a punishment of rupee 1 on him. On the other hand, there was maximum punishment which had been announced in case of Justice C.S. Kannan. So there are several amendments which need to be brought into the law in order to see to it that there is equal punishment which is given to the vote. And the fourth most important pillar of our democracy is media. In the case of Justice C.S. Kannan, what had happened was there was very selective coverage of the case which had actually taken place. So media should not actually deal themselves into all this. They should try to bring out the true facts of the case so that these contemners can be given the right kind of punishment that they're supposed to. So this is all I have to say about the case, and I hope that things change soon for the better. Thank you.